Thank you, Laskeric. I welcome the opportunity to speak on this bill today. I think it is a positive piece of legislation and one which is long overdue. This bill is designed to assist the rehabilitation of offenders in securing employment. It is a bill which will bring us into line with the majority of EU member states in providing a system under which certain convictions can be disregarded after a number of years have elapsed since they were imposed. This is not a job creation piece of legislation. However, it will provide a small piece in the architecture of what this government is trying to create, a jobs-friendly economy. It will make it easier for people with minor past convictions to obtain and secure employment. But I do have one issue regarding the bill which I would like to focus on today, and that is the provision allowing for only 2 convictions to be spent. I believe the reasoning behind this provision is aimed at repeat offenders or so-called career criminals. However, I do believe there are a number of people who will undeservedly fall foul of this provision. I'm speaking particularly of individuals who may have 3 convictions which relate to the one isolated event or transgression. One incident can include 3 or more relatively minor convictions. For example, an individual may have been involved in a traffic incident as a young person. That one transgression could lead to that person being convicted of 3 offences for that one incident, such as driving without insurance, leaving the scene of an accident, and driving whilst perhaps on a mobile phone, which is fairly relevant today. I want to refer to just an email in that regard from a constituent of mine. Briefly, my one incident was that I reversed into another car in the car park of a local disco as we were leaving the dance. I was uninsured and did not remain at the scene. The damage was minor. I broke my rear lens and damaged the other person's car wing, and I fully compensated that other person. However, at court I was convicted on 3 charges. Section 106 of the Road Traffic Act, failure to stop at the scene of an accident. Section 53 of the Act, dangerous driving, licence endorsed. And Section 56, no insurance, licence endorsed. Now, that man was 18 when it happened. He's now 50 today. It seems to me quite unfair that one person who demonstrates perhaps a pattern of crime or law-breaking resulting in 2 convictions can spend their convictions when someone who committed 3 offences within the one isolated incident will continue to carry those convictions with them. This individual may only have seen the inside of a courthouse once, yet they carry 3 or more convictions for the one incident. It must be said that the safeguards within the bill are strong and ensure that those with serious convictions, including those in respect of sexual offences and offences tried by the Central Criminal Court, are excluded from the benefits of the bill.
1 minute, Ed.
This bill is not about allowing serious criminals expunge their record. In summary, I would ask that the Minister review the provision stating that not more than 2 convictions can be spent and bring forward amendments to the bill at committee stage. I believe I've explained the anomaly and how it does work, and I don't think that would have been the intention of the bill. I'm more than happy to meet the Minister and discuss this matter further. I welcome the bill, the intention behind it, and the vast majority of provisions contained within it.
Deputy Michael Healy-Rae.